Good morning, everyone. Thank you for joining our program with our guest speaker, Professor Lisa Sachs from Columbia University. It is our tremendous pleasure to have you all this morning. I'm Aubin, and I'm going to say a few words about our program before handing it over to Professor Victor Flatt. So our program is funded by the European Commission in the framework of the H2020 and Mercury program. And every month we convene guest speakers to address different challenges in energy, environment and natural resources, law and policy. Our series will feature on December the 1st, Professor Troy Rule from Arizona State University on a topic relating to renewable energy law. So feel free to visit our website, www.uh.uh.uh.edu/inner-center. From now on, I'll turn it over to Professor Flatt, co-director of the Environment, Energy and Natural Resources Center at the University of Houston Law Center, and our chair this morning.
Thank you, Aubin, and welcome everyone. So we are doing this, now we're using sort of the Zoom focus to make it more informal. Most of our audience will be coming in later to watch the recordings, but those of you who are joining us now, I really appreciate it. And the first thing I will note is that any questions you have as Professor Sachs is making her presentation, please put in the chat function. I'm going to moderate the chat, and then we will have time at the end to answer some of those particular questions. So my pleasure really to introduce this month's speaker, Lisa Sachs. And Professor Sachs is the director of the Columbia Center on Sustainable Investment. And since joining that center in 2008, she has established and now oversees the Columbia Center Sustainable Investments research portfolio in its areas of expertise. And in so doing, she's overseen advisory work in Chile, Guinea, Malawi, Mozambique, Namibia, Paraguay, Tanzania, and Timor-Leste, and other countries as well. She also teaches a master's seminar at Columbia Law School and Columbia School of International and Public Affairs on extractive industries and sustainable development. She has also lectured at the Extractive University in Colombia on international investment law. She has served on the World Economic Forum Global Future Councils on International Governance, on mining and metals, and is a co-chair of the UN Sustainable Development Solutions Network's thematic group on good governance of extractive and land resources. She was studying sustainable investing and its implications before many of us, including myself, had really taken full notice of this massive change that was going on. As the global transition from a carbon economy accelerates, more and more money is searching out sustainable opportunities, and yet standards for these opportunities are not uniform and are in flux. Moreover, as Professor Sachs will discuss today, existing investment standards, sustainable ones and not sustainable ones, may be creating other environmental problems going forward. We have looked at a lot of this in terms of investing in renewable energy, but renewable energy investment is also going to require investment in mining in rare earth metals that power the electricity revolution that's coming. Today, Professor Sachs is going to speak on a growing number of state investor dispute settlement claims, which is abbreviated ISDS, and how these claims and awards on those claims may be challenging critical and important measures that states are taking related to climate action and to ensure that the minerals needed for the energy and digital transformations are mined responsibly. This talk will touch on the ways in which our current investment law regime, including the ISDS, which is included in thousands of investment treaties, may be undermining environmental conservation, governance, rights, and justice. And so without any further ado, I will turn it over to Professor Sachs. Thank you.
Great. Thank you so much for including me. It's really a pleasure to be with you. And as I was just saying to Aubin and to Professor Flatt, I really hope to keep this informal, as you said, and to welcome discussion and questions at the end. I'm As you heard, I teach on each of these subjects separately, on the governance of natural resources and on investment law and policy. Each are huge themes in and of their own right. But I think that thinking about their high level interaction is really critical. And so I'm grateful for this opportunity that, as I was just telling Professor Flatt and Aubin, led me to think about their collision even more. And so grateful to be able to discuss that with you. Thank you so much for the really generous introduction. I'll maybe just say one more word about the center that I direct, which I think might contextualize some of these remarks. Our center, we're based at Columbia Law School. We're dedicated to, as we say, the study and practice of sustainable investment. To me, that means the role that investment plays in achieving sustainable development goals and human rights. And we focus on the laws and the policies and the practices and the range of actors that shape the impact that investment has on sustainable development. We look critically at what's not working and the aspects of governance regimes that allow for the impacts that we see, but we promote approaches that mitigate these impacts and that can help to maximize investment's contribution to our global goals. I've been at the center for 13 years more, and actually worked at the embryo of the center even before that when I was at Columbia Law School. For that entire time, for over 15 years, I and then the center have focused in particular on the governance of investment in natural resources, and also on the role and impacts of international investment governance because of their particular importance to the sustainable development challenge. So today, as you heard, I asked to speak actually about their collision. That is how the investment law regime constrains government's ability to regulate their mining and energy sectors and risks undermining critical climate action, as well as broader sustainable development goals. So let me start, if I can, with a look at the role of the mining and energy sector in sustainable development and the challenges really of governance in this sector. I've been saying for 15 years that extractive industries, oil, mining, and gas are really at the heart of the sustainable development challenge. I now quote Professor Sachs, Professor Jeffrey Sachs, who in one of the opening sessions of a massive open online course that we produced several years ago on extractive industries and sustainable development, he said that mining, although one could say the same about oil and gas, has been so important because of the materials that it produces and the technologies and tools that it enables, that we have defined the timelines of human history according to what has been brought up from the ground. I think we're in one of those defining eras actually right now. For fossil fuels, it is most straightforward. We are obviously deep in a climate emergency. Fossil fuels account for the vast majority of greenhouse gas emissions, for over 65% of greenhouse gas emissions. And we're now in an existential sprint, really, to decarbonize our national and global energy systems, our transport systems, our industries, heating, electricity, and so on. One of the most important reports for our generation, but this year, is that of the International Energy Agency, which stated unequivocally that we have no room in our carbon budget for new fossil fuel projects. And other researchers have shown that to have even a reasonable chance of keeping global warming below our agreed limit of 1.5 degrees warming from pre-industrial temperatures, we have to leave a substantial amount of our known fossil fuel reserves in the ground, of our proven reserves. An important, again, in my view, analysis in Nature this year estimated that in order to have even a 50% chance of keeping warming to that level, although I'll note that my colleague at Columbia, Professor Gerard, who teaches climate change law, always says you would never get on a plane if they told you you had a 50% chance of landing. But in any event, a lot of our estimates are only giving us this 50% chance of keeping warming to these levels. This article in Nature estimated we'd have to leave 58% of our known oil reserves unextracted, 59% of our fossil methane gas, and 89% of our coal reserves. So what that means is that many fossil fuel projects and plans will have to be abandoned or phased out quite urgently. Of course, current policies, national policies, and private sector policies are nowhere near on track, but that's the direction, that's the science, and that's the direction that we need to be headed. For the mining sector, the implications of climate change and the energy transition are very different, as Professor Flatt noted. There will continue to be a role for many minerals and even potentially a greater demand, maybe a much greater demand for many of the minerals that are needed in the energy transition, for instance, those used in wind turbines or solar panels or batteries, and also for our growing population and our increasingly digital and automated economies. I always say that there's a potential for this growth in demand because the technology is ever evolving, and it's difficult, if not dangerous, to rely on current projections for demand. There's also a push for more circularity and recycling, more efforts to reuse and recycle minerals, which will affect demand. But regardless, mining will continue, if not grow, in the near future. For many mineral-rich countries, including those that I've worked with and studied, the mining sector is a key source of wealth, often the main one. And mining has the potential to contribute to, in addition to the important capital flows, to critical infrastructure gaps in most of these countries in transport, power, water, information and communication technologies. Those contributions are not automatic, but if planned for, the mining sector can either help to finance critical infrastructure, because the mining sector needs a lot of that infrastructure for its own operations, or as a major consumer of those infrastructure, the mining sector can serve as an anchor demand to expand accessibility and affordability of the critical infrastructure in the regions in which mining takes place. The mining sector can facilitate technology transfer, skills transfer. It can create jobs. Again, all of those have to be properly planned for. But on the other hand, and another reason that to my mind, mining is at the true heart of the Sustainable Development Challenge, is that mining projects are also extremely resource intensive. They require land, energy, water, and it's likely that the increased or even the continued demand for minerals will push mining into new frontiers or into harder to reach deposits, which will require even more resources at a time that those resources are constrained by growing populations and especially by our changing climate and by other environmental crises that we're facing. On top of that, these projects often take place in remote or more impoverished communities, sometimes requiring displacement of the communities or of other livelihoods. And historically, the track record of the mining sector has not been great. Both companies and their government counterparts have contributed to or have enabled sometimes devastating social and environmental impacts. We continue to see violent confrontations with communities, catastrophic dam failures, allegations of corruption, tax avoidance, and more. And even on the benefit side, few countries and even fewer communities have earned the revenues or have benefited as much from these projects as they originally expected. So these large-scale mining projects have long-term and determinative impacts on the environment, on human rights, on communities, on economies. they are among the most complex and consequential projects on the planet. So the laws and the policies and the regulatory processes that governments put in place are critical. They are critical to realizing the benefits that are possible, and they are critical to mitigating the impacts, including the impacts that are to some extent inevitable. And the sheer scale of the projects, of the impacts, the domestic significance of these projects means that the law governing these projects is incredibly complex. The law has to require or has to specify the requirements and the processes to allocate the rights to explore, and then separately set the conditions that have to be met and the terms on which rights to mine a particular deposit might be able to go forward. And those obligations must and do include approval of feasibility studies, environmental impact assessments, environmental management plans, consultation with local communities, agreement on land and water use, agreement on infrastructure needs and sharing and financing, plans for processing, transporting or selling the ore, including what can be processed locally and domestically, plans for local hiring and economic benefits, land use licenses, and so on. And only if all of those prerequisites are met will the government allocate extraction rights that, again, are subject to legal and fiscal regulations and laws. And also importantly, at multiple stages in exploration and extraction, there are opportunities for other stakeholders to, within and outside of the government, to review and to challenge these decisions and these outcomes. So we have judiciaries that review administrative decisions, citizens who are empowered to contest permits or contracts. And again, this is for good reason, particularly for these large projects with potentially transformative impacts. We want governance systems that integrate checks and balances that involve actors with different interests and areas of expertise, and to allocate the rights and responsibilities among stakeholders to assess the validity of some of these legal processes, to check the adequacy of impact assessments or management plans, to question the negotiated terms, and so on. So these checks and balances and processes are important. They're critical to the ability of the sector to contribute to sustainable development. And by the way, it's also important that the government has the flexibility to adapt over time, and that these checks and balances continue, because these projects last decades and the markets change, the technology changes, the environment changes, the skill levels change, and the government needs to be responsive and adaptive to these changed circumstances in such a critical sector. So that's half the context setting. I wanted to emphasize not only the complexity of the governance of extractive industries at the national level, but also the importance of the governance of extractive industries at the national level, how important the mechanisms and the rules and the complexity and the checks and balances and the flexibility are to ensuring that mining contributes to countries' sustainable development goals and doesn't undermine them as it has. In the case of fossil fuels, the urgency and the imperative of countries taking steps to move away from and phase out oil, gas, and coal projects is key. In the mining sector, it's more how to mine sustainably to meet the mineral needs of our growing and evolving economies. So I wanted to emphasize that before now shifting to looking at the investment law regime, the international investment law regime, and its impact on this domestic governance and the ability of governments to take these critical steps. So to shift now to the investment law regime, which may be an introduction for some of you. For some of you, you may be expert. It's, I would say, not as well known or understood as it should be, given its importance for government's regulatory space and our ability to meet the Sustainable Development Goals. So as Professor Flatt said, the investment law regime is made up of thousands, over 3,300 investment treaties, bilateral and investment treaties that govern foreign investment. These are either, the majority are bilateral treaties, so treaties between two governments, Canada and Peru, for example, or multilateral investment treaties. It might be regional investment treaties, where the entire contents of the treaties relate to the obligations of host governments, so governments that are receiving investment, to protect foreign investors. Sometimes in roughly a quarter maybe of these treaties, they are investment chapters that are embedded in a broader trade agreement. The one that you'll definitely be familiar with is the NAFTA, or the new NAFTA, the USMCA, which has an investment chapter, and that investment chapter looks substantially similar to these standalone investment treaties. The basic idea of these treaties, which are relatively recent in legal history, by the way, they only started in the second half of the 20th century and really grew in the 1980s and 90s, although they continue to, but the proliferation was in the 80s and 90s. The basic idea, the purported idea of these treaties is to promote cross-border investment on the assumption or the premise that, a couple premises. One is that the additional legal protections for investors that are in these treaties will promote investment. And the second is that more investment will bring more economic development. We'll revisit those shortly. But what these treaties do is that they impose obligations on host states, so on the governments receiving investment, to, for instance, not discriminate against foreign investors on the basis of their nationality, to not expropriate without appropriate compensation, and so on. They also include vaguer protections. For instance, the obligation for host states to provide fair and equitable treatment to investors, or full protection and security to investors. Unlike in almost all aspects of international law, for those of you studying international law, what's unusual about these treaties is that investors can enforce these protections directly against governments in ad hoc international arbitration proceedings. That's what's called investor state dispute settlement, or ISDS. And investors can and do challenge any type of government policy or measure, a judicial ruling, an administrative enforcement, even government inaction, which has happened, the failure of a government to take action that the investor believes or alleges has breached its protections or the host country's obligations under the treaty. The cases are heard by party-selected arbitrators, so the investor and the country select arbitrators with extremely limited means of participation of other affected parties. So communities and other ministries that might be relevant to the topic do not have an avenue of participation. Domestic rules and laws are not applicable. So really, the determination is subject to the interpretation of these party-appointed arbitrators as to whether these investment protections were breached. And the awards are almost always, not always, but almost always for monetary compensation. So requiring the government to compensate the investor, often including the lost profits that the investor alleges stemmed from the government's action or inaction. So the investor says that a project couldn't go forward for X reason. They therefore lost many billions of dollars, and that is the basis for the claim and the possible award. There are many issues with this mechanism, far too many to address in this brief session together, although I've written a lot on this, teach on this, always happy to talk more about it or to share resources. But I wanted to emphasize, for the purpose of our discussion, one major aspect, and that is that the majority of the more than 1,000 known arbitration cases, not all are known because despite their public nature, by definition, they are not required to be made public, nor the proceedings to be made public, but we know of more than 1,000 cases. And most of them have not related to bias on the basis of nationality or to expropriation or to lack of due process in local courts. Instead, what we have now seen from, like I said, this recent, the treaties are from the 90s, the cases are all just from the past 2 decades or so. What we're seeing is companies using this mechanism to challenge the very measures that we've just said are not only proper, but necessary for the governance of critical sectors like the extractive sector, when those measures impact on the profitability of investors. In those cases, investors claim that actions that the government has taken are unfair or discriminatory, mainly because they, to use the term of art from ISDS, frustrate expectations of the investor and the expected profits of the investor in these complicated projects. So the types of challenges that we've seen in cases, successful challenges, by the way, are investors challenging requirements to consult with communities, requirements to compensate communities for harms, changes in fiscal regimes or taxation laws that are adapting to new information or changed circumstances, or when governments realize that they are not recouping the expected revenue flows that were negotiated at the outset. Investors are challenging permits that are not granted or that are revoked because the environmental impacts are assessed to be too great. They're contesting even requirements for environmental impact assessments or what's required to be considered within environmental impact assessments. For instance, a requirement or a recognition that a community's values matter from an impact assessment. Investors have challenged the inaction or the failure of states to suppress community opposition when communities have opposed mining projects because of the impacts of the project on the community's resources. If communities have expressed or have tried to express their grievances, investors have challenged the states not quelling those protests or protecting the investor and the investor's ability to operate despite the community protests. And recently, in the past several years, investors have challenged several governments for steps they've taken to decarbonize in line with their Paris Agreement commitments. So governments that have taken steps to phase out coal-fired power plants or put a moratorium on fracking. In the US, not approving the infamous Keystone pipeline, that has been challenged. TransCanada has filed a $15 billion claim against the United States for not approving the TransCanada pipeline. And again, despite the fact that these cases are challenging specific, if not critical, aspects of domestic governance for these large, complicated projects that are designed, the regulations or the enforcement actions designed to balance the potential benefits, but also the major risks and the roles and the interests of many domestic stakeholders. These cases are heard outside of the domestic context, sometimes challenging the determination of local courts or local institutions, even without alleging any impropriety or bias of those institutions or courts, just that they didn't agree with those courts or institutions, or that the determinations of those courts or institutions frustrated the expectations of investors. They don't allow for the participation of the stakeholders that are affected by the underlying dispute or by the outcome. And in each of these cases, for a host government to say that they are complying with domestic law or with international commitments like those under the Paris Agreement or with human rights obligations or the requirement for prior consultation. Those are not recognized defenses in investment law. Sometimes when they're raised, arbitrators say, okay, so we understand why you took that measure, but the measure nevertheless breached your obligation to the investor. So you have to compensate the investor not only for sunk costs, but for losses for all the future profits that were anticipated. Let me highlight one particular recent case against Pakistan. An investor, a proponent of one of these exceptionally complicated projects that had not received necessary approval, so there was no contract in place, no terms had been agreed. The project faced tremendous community opposition, in part because of contested issues of land rights, water usage, and so on. So it was unlikely to have received a social license to operate, never mind the legal rights that it had not secured. But the investor, frustrated at the denial of requisite permits and licenses, challenged this in arbitration, and successfully. The tribunal found that the government's actions and inactions breached the protections for the investor's expectations, and ordered Pakistan to pay $4 billion in lost profits to the investor for a project that was never approved. It was never started. The terms had not been agreed, precisely because the terms had been contested. So Pakistan has been ordered to pay $4 billion plus $2 billion of interest. So the award is $6 billion against Pakistan in favor of an investor. By the way, coincidentally, but tragically, equal to the same amount that Pakistan received in emergency financing from the IMF because of its extreme poverty and extreme financial instability. Literally equal amounts, not literally, but approximately equal amounts, $6 billion in emergency financing from the IMF and a $6 billion award to an investor who had never secured neither the social nor the legal rights to extract. This is one of—
Wait, Professor Sachs, I'm sorry.
Yes.
I just want to interrupt you with a clarifying question. This is so unbelievably fascinating. I'm just jumping the line quickly. So I understand what you're talking about exactly. You know, there are these agreements that people sign so that they, you know, their investment expectations are protected, et cetera. And yet, you know, what you've indicated is that domestic law, certainly, but apparently even international law is not taken into account in these. But it strikes me that, is there some reference to any law? So just let me give you my point of view. So let's say if somebody wanted to mine something somewhere in Pakistan, and it would require Pakistan to like kill 10,000 people. If they decided not to kill 10,000 people, could they be sued? Aren't there any background principles like you can't murder people, or, you know, some background legal principles for these?
No. There aren't. And in fact, in one of the most incredible awards against not Ecuador, maybe Ecuador or Costa Rica, it's terrible that I can't remember at this moment, but it was a factual scenario that was not crazily dissimilar to what you're describing, where there was violent community opposition, really violent community opposition that halted the project. And what the investor objected to is that the government didn't shut down that community protest. And what the tribunal said, I wish I had the language here, but I remember part of it, which is that it's hard, the tribunal said, it's hard to know what the government could have done to have resolved this situation. It hardly could have, Quito, so it was Ecuador, hardly could have waged war on its own people. But it's clear that the government couldn't have done nothing. And the investor won. The investor was awarded millions of dollars in that case. So the tribunal doesn't even have a sense, nor does it find itself required to engage in a consideration of what appropriate government conduct would be in each case. In other cases, again, the tribunal may say, we understand that you have to take these environmental measures, but that doesn't excuse you from having to compensate an investor for having to take them. By the way, another crazy set of cases in Romania, where in Romania, there had been a cyanide leak, which was subject to a human rights case against Romania for the failure of Romania to have protected its community from the leak in its water. Fast forward a few years, and Romania is putting in place more robust environmental impact assessments and measures to prevent such a leak. And a company now, frustrated by the impact on its project, is suing Romania for $4 billion for not approving the environmental permits and allowing a potentially impactful project to go forward. And the complete incongruence with the previous international human rights award against Romania for failure to protect its citizens from these types of pollution of the water is irrelevant to the determination. I mean, let me clarify one thing, which is that the tribunals often find them to be irrelevant. Could they be relevant? Sure. The language in the treaties says that other aspects of international law can be relevant to the interpretation of the treaties. But it hasn't been relevant in the sense that it has contextualized the actions of the governments and therefore what an appropriate balance might be, or what an appropriate what appropriate actions governments should be expected to and allowed to take despite their impact on international investment.
So sorry for that interruption.
No. I'm eager for the questions.
I just couldn't understand. Well, please finish other remarks.
Okay, I will maybe make just a few more points that I had thought might be relevant, but then I'm really keen for more questions and discussions. One thing, just referencing again this Pakistan award of $6 billion, my colleagues and I calculated what percentage of these claims related to the extractive sector were brought against countries, low-income countries. And this is now a couple months old, and there are new extractive cases literally every week. But a few months ago, we calculated that 86% of extractive claims, known extractive claims, so claims related to the extractive sector, were brought against countries with a gross national income of less than $12,500 per capita, which makes the sizes of these awards ever more extraordinary. So I'm keen to have discussion. So maybe I'll just take my step back and end with some broad reflections, both on the international investment regime and on natural resources and sustainable development more generally. On the international investment regime, I mentioned that the premise of the regime is that these treaties that provide additional legal protections to investors will promote greater investment and therefore more economic development. 2 decades of empirical research into this premise has not yielded any conclusive evidence that these treaties have actually led to greater investment flows, let alone economic development. We do know that the treaties have changed how investors structure their investment, in part because law firms advise them to do so. So there are plenty of public law firm advisories saying Tanzania is planning to implement these new regulations, including requirements to do more processing domestically. For instance, of course, Tanzania is doing that to try to benefit more from its extractive sector. And the law firms say, so any investors who are either invested in Tanzania or considering investing in Tanzania should structure their investments so as to benefit from these additional legal protections. So it's now possible to plan legal structures and encouraged to plan legal structures to benefit from these treaties, much like tax planning. But the purported benefits to states of increased investments are unproven. There's no evidence that it has yielded more investment, let alone better quality investment. And I should clarify that the reason I'm in a center on sustainable investment is because of the critical role of investment in achieving sustainable development. What brought me to this field is how do we mobilize the trillions of dollars of financing and investment that are needed to achieve the sustainable development goals. So I certainly am in the camp wanting to promote sustainable investment, but this mechanism, the premise of these treaties altogether was simply that legal protections would accelerate or would encourage or facilitate or increase investment flows, has not panned out. And yet the costs are extraordinary. I've only literally scratched the surface, but what we've discussed, and then there's so much more that could be said, but these treaties provide extensive substantive and procedural privileges to foreign corporations that are not available to communities, to indigenous peoples, to other domestic actors, including domestic investors, to other actors within the government. The effect of the treaties is that of the cases has been that governments have to compensate companies for sometimes companies' own failures in environmental or social protection, or for government's legitimate exercise of their responsibility to govern these major projects and to try to maximize the benefits and minimize the harms locally. So it tremendously shifts the risks and the costs of those measures onto the citizens. And from a climate perspective, even the threat or the risk of these cases can deter government regulation or enforcement. And that has been well documented, and it's called in this field regulatory chill. Governments are sometimes explicitly, sometimes implicitly deterred from taking similar measures, phase out of coal plants or transitioning fossil fuel related infrastructure or decommissioning certain projects because of the legitimate fear of multi-billion-dollar cases, which are expensive even to defend, never mind the extraordinary crippling costs of losing a case like this. So we've only scratched the surface of the regime and of its implications for sustainable governance of natural resources. But I hope, as I was saying to Professor Flatt and Aubin at the beginning, that this just provokes inquiry and reflection, not only, by the way, on the risks and impacts of this system, but on what role international law could play in helping to address the very real challenges of sustainable natural resource management. So how could international investment law help to rapidly and equitably decarbonize our economies? How do we balance company interests and the needs of the private sector, which we need and want, with the responsibility of governments to take decisive climate action or otherwise to respond to their constituents? Which stakeholders are affected by these projects and these issues, and how do we ensure that their voices and interests are represented in any dispute resolution mechanism? What role do consultations and impact assessments more broadly play, and how can those processes be supported and reinforced? And I would say, how can domestic processes, given their importance for the governance of the sector, more generally be supported and reinforced to bring legitimacy and resources and credibility to domestic processes and outcomes? Right now, none of those big picture questions that I've suggested are addressed in the current investment law regime, which is limited to providing protections and privileges to investors, again, based on this outdated assumption that protections will yield beneficial investments. So we at our center are trying to rethink what investment law could look like that would help to advance our shared goals, including those of the private sector, which we critically need to realize the materials of our future. So let me stop there and clarify anything or see if you have thoughts or questions, and of course can go much more deeply into any aspect that I've mentioned.
Thank you so much. This is so very interesting. Just a reminder to the people who have joined us that please feel free to submit any questions through the chat function. I and Professor Nzaou will curate those, but I do have a burning question. You anticipated my first question, which is these ISDSs were, ostensibly created to further investment, right? And you've already addressed the fact that it doesn't seem like there's empirical evidence that they have necessarily done that. So if they were useful, maybe they've outlived their usefulness. Well, why aren't countries abrogating these treaties, right? What should happen in international law? Why aren't everybody just saying, we're not going to abide by these treaties anymore. We're done. So something's keeping them involved. What's going on here?
That's the $1 million question that would let me retire too. I think it's really a question that we're trying to understand all the time, and at least two answers are politics and the interests that are behind the system, and the continued narrative that these treaties are necessary to signal even a stable, predictable legal regime for incoming investment. So while these treaties are bilateral by design, or they are, the governments on both sides make commitments to the respective investors, de facto, they are lopsided treaties. The original ones were largely between capital exporting and capital importing countries. And of course, capital exporting countries continue to want to protect their investors. So there is a lot of diplomatic pressure on capital importing countries to preserve and to expand these types of protections for the benefit of the capital exporting countries. And by the way, that goes all the way to international organizations, including the World Bank, which still advises developing countries to sign on to these treaties. So that's at least one piece of it, is that there are a lot of interests in maintaining the current system, including, by the way, substantially by the arbitration community itself, which likes the system and is very active in discussions. And so there's a lot of power in that, especially with the countries that are most affected by it. That's one piece. I think the second piece that's quite related is that governments, especially lower income governments, really need and want investment, and are not well supported in thinking through what other ways to both signal and attract investment. And that's related to the first, because we're not creative or supportive enough to think about what meaningful investor attraction and support might look like. So these treaties are often signed by ministries of foreign affairs or ministries of commerce that want to signal an openness for business. They want to assure investors about the stability of law, and don't have great alternatives. So I think that's very related to the first. The last half point I would add, but maybe it deserves a full point, is that this is really we're just understanding these impacts relative to other areas of international law. So most of these cases are within the past 10 to 20 years. And we're just seeing now what types of issues are being challenged and what the consequences are. And I think that part of this is helping governments understand what the risks are and how this impacts on their ability to govern domestically. And then, by the way, those who feel the impacts because they are either defending the cases, or they are the environmental agencies, or they are the constitutional courts that are being overruled, they are not the ones negotiating the treaties. So there are internal, political structures that I think make the learning slow. Those that are most affected by these treaties are not the ones negotiating them, sometimes are less powerful than the ones negotiating them. So that's part of I think what is before us in the coming years is to facilitate a more thoughtful, interdisciplinary, interministerial, but also international conversation around our shared goals of increasing investment, ensuring that it's governing sustainably, and looking at how international law can send the right signals, provide the right supports and cooperation, and so on. And how do we start the conversation from there? So those are my best guesses to your question.
Well, more power to the Sustainable Investing Center, because it sounds like a lot to deal with, but that's interesting. So I've got quite a few more questions. Anybody else wants to ask one, that's okay. But we don't have much more time, so I'm going to actually combine a couple together. So sort of connecting this now to what we're seeing going on in the world, we saw a massive amount of funding being talked about and rolled out, particularly after Glasgow. We see that there's maybe too much money chasing too few green investment opportunities. So two questions about that. One, how much of ISDS issues will connect over to these investing vehicles? Because I know that sometimes the investing vehicles, it seems that there's a possible way it could impact in two ways. One, they are under pressure to not invest in things that could cause environmental destruction. On the other hand, they are under pressure to invest in things like cobalt or mining or other things that can actually ease the transition. So that's one piece of it. And the bigger piece of that is something you referred to at the very beginning, and I think about too. How do you constrain or manage this private activity when it seems to be, at least in the world we're in now, leading the way, financing new investments on sort of climate progress? Or maybe it isn't, but okay. So that's my two-part question. I'll stop there.
Yeah, no, I think I think they are very related. What I think we need is a global, but actually especially national and regional frameworks for investment. The investment that's critically needed in infrastructure, in mining, and so on should be part of a government-led plan for national economies. Well, there are two. On the energy side, we need government plans for energy system transformation. Where is new production needed? How would that connect with the grid? What are the regional implications? How will it be distributed? How will it be financed? And so on. That cannot be done by just opening the doors to investors and assuming it's going to work out. We need a government plan for that. On the mining side, again, we need the private finance in mining in most places, but to the extent that that actually realizes the benefits for host governments depends similarly on that framework. So we need the government plan, and companies should support and understand that. That will strengthen and support the viability and the bankability and the stability of private sector investments if it's done within the context of a national plan. But by the way, governments need support in that planning process. And they need financing for the public investment components of it. That there have been a number of commitments, but the financing hasn't been forthcoming. So that's one piece of it. The second piece of it is that these are risky investments. I mean, investors and especially financiers need assurances, and they need projects to be de-risked. That is the bucket that ISDS falls in. It provides some type of risk insurance. I think we should look at other types of risk mitigation measures, public guarantees. What are other roles that international institutions, the Multilateral Investment Guarantee Agency, other overseas private investment corporations, others, what other ways can we de-risk or reduce the risk of these types of projects to provide assurances to, or the necessary assurances, so to speak, of private investors that their investments will be protected. So I do think you're right that this ISDS comes up in this context, because in the absence of other mechanisms and other, in clarity around how to assure the viability of these projects, there's a default to rely on arbitration, which, by the way, just to your point, this ISDS is not only within treaties, it is also within individual contracts. It can be in national investment laws and so on. So it is one of the default mechanisms to provide an additional layer of protection. So I think if I could summarize that meandering answer, it would be, yes, we need to have mechanisms to address the risk, to de-risk projects, to provide public guarantees for projects that are legitimately part of the energy scenario. We should be thinking about those other than ISDS because of the costs of ISDS, and within the context of public plans for a combination of public investment and private investment that gives greater visibility and support to where private investment can usefully fill in the necessary gaps.
Well, I hope we actually get to that. I worry our governments are not keeping up rapidly. We have one more question. That's quite a question. Let me see if I can summarize it here, because that needs to be our last question. It's similar to the one that we were discussing. What do you do when regulations have been in place before the initiation of the investment? You can't surprise the investor. Does that artificially balance expectation that an investor might lending support to their future clients if they expected access to certain profits of a project? I guess
it's a great question.
And then that'll be the last one, but okay.
Great. It's a great question, and it goes right to the heart of many debates that we currently have. What are legitimate expectations? How do we define what are the legitimate expectations of investors? Should investors legitimately expect that when they invest in a 40-year project that the legal framework will not change for 40 years? Should investors currently investing in fossil fuels now have any legitimate expectations that those projects should be fully protected and fully compensated at today's value? I think you can half answer that question yourself, that there's a debate on, but I think you're absolutely right. And alas, in this system, the assessment of what is a legitimate expectation falls entirely to the interpretation of the arbitrators. So that would certainly be part of the defense when these cases arise, would be how could that be a legitimate expectation? But there are cases. There's no precedent in the system, but of course, arbitrators do look very much at cases in the past, and there are cases where arbitrators have said that investors have an expectation to a stable business environment. So essentially, arbitrators saying investors can expect legal stability. Many of us would disagree with that, but that literal ruling from Occidental v. Ecuador has been quoted many times since. So I think you're asking exactly the right question. Should these be legitimate expectations? Should we be protecting those? What do we mean by legitimate? And how do we ensure that any protections, balance those factors? It's a great question.
Thank you so much. This has been such an interesting presentation. And again, the Environment, Energy, Natural Resources Center, we exist at the intersection of environment, energy, climate, and the business that goes into those things. So this has been very appropriate for the series. Thank you so much, Professor Sachs. Thank you, Professor Nzaou. Any last words, Professor Nzaou or Professor Sachs?
Just Thanks so much for me too. And I really, really look forward to continuing the discussion with all of you.
Yes, thank you. And this recording will be posted. Thank you all for coming. And we look forward to seeing you at our next presentation, which will be on December 1st. Thank you all. Bye-bye.